Let's start. So we did from section 3 to section 22 in this topic. Let's first start with what we understood under section 3. So section 3 basically talks about what is the minimum number of members required for the purpose of formation of a company. So what is the minimum number of members required? If it is a public company, 7. If it is a public company, then 7. Private company, then 2. And 1-person company, only 1 member is required. So this is the minimum number of members who are required to start the company. And under this section, there's another section which is section 3A. And section 3A tells us what? It tells us that in any situation, if the number of members in any company goes below the minimum requirement. So, if number of members go below the minimum number, then what? Then in that situation, the corrective action, or rather in that situation within 6 months the corrective action shall be taken and the minimum number of members shall be reached upon. However, if the company does not make sure that within 6 months this requirement is fulfilled, then what will happen? Then all members who are cognizant of the fact, who are aware of this fact that the company is doing business with a reduced number of members, will become severally liable for all debts. Severally liable for debts after 6 months. They will become severally liable for all debts after 6 months. So up to 6 months it is okay. Up to 6 months it will be the company's liability, but post that it will become the members' liability. So this is what we saw under section 3 and section 3A. The next section which we started with was section 4. Section 4 talks about the memorandum of association of the company. Under MOA, we have understood what are the different clauses of memorandum. So what are the different clauses of memorandum? We started with the name clause. What does the name clause state? The name clause states the name with which the company will be incorporated should end with the word limited if it is a public company, should end with the word private limited if it is a private company, and the name of the company should not contain any undesirable terms. There shouldn't be any undesirable terms. And if it wants to use certain terms in certain situations, it will have to obtain approval of central government using words like national, royal, charter, queen, any of these words. They'll have to first obtain approval from the central government. If it wants to use the word bank in its name, it will have to obtain approval from the Reserve Bank of India. And if it wants to use the word exchange in its name, it will have to obtain approval from the SEBI. That is, it will have to obtain approval from SEBI. So these are the approvals which are required whenever a company is stating its name. Now the name can also be reserved for a specified time. If it is a new company, then the name will be reserved for 20 days. If it is changed in the name of an existing company, then the name will be reserved for 60 days. And if the company is not incorporated within this time span, then the reserved name will be the reserved name will be cancelled if the company is not incorporated within this time span till the time the name was reserved. And also we have understood that if it is a 1-person company, then the name should have the word 1-person company or OPC written in the name. So this was with respect to the name clause. The second clause which we understood was the situation clause or it is also called as the registered office clause. What does this clause state? This clause states the name of the state where the registered office is situated. Name of state where the registered office of the company is situated. And it says that within 30 days of incorporation, there should be a registered office established by the company. So, within 30 days, the company should have its registered office from where it is going to carry out its operations. All the documents of the company will be stored at the registered office of the company only. So, that was the second clause. The next clause of the Memorandum of Association is our object clause. Now, object clause is the most important clause of the Memorandum of Association. Why is that so? Because it lays down the objective, lays down the objects, power and scope of the company. It lays down what is the thing which the company is going to do post its incorporation, that is, what is the business which the company is going to carry out post its incorporation, and the main purpose, what is the purpose behind setting up of the company. All of this is stated where? It is stated in the object clause. If a company does an act which is beyond its objects, beyond its memorandum of association, it is said to be ultra vires. And here we have also seen the doctrine of ultra vires, and it states that any act done beyond the scope of the memorandum is null and void, will have no legal effect. Any act which is beyond the scope of memorandum of association of the company is null and void, it will have no legal effect. So, all of this is again related to the object clause of the company. Moving ahead, the next clause of the memorandum is the liability clause. Now, liability clause will differ from company limited by shares and limited by guarantee. If it is a company limited by shares, there the liability of members is limited to the unpaid value on share, and if it is a company limited by guarantee, then the liability clause shall state the agreed amount of contribution which the member has agreed to contribute upon at the time of winding up of the company. That is what shall be stated in the liability clause of company limited by guarantee. In case of an unlimited company, there is no liability clause at all. Then comes in the next clause, which is the capital clause. Now, capital clause, it states the amount of authorized share capital of the company. Authorized share capital is the maximum amount which the company can raise by way of issue of its shares. It not only states the authorized share capital, but it also states the number of shares in which it is divided, the face value of shares, etc. All of this is stated in the capital clause of the company. Post the capital clause, there is subscription clause. What does the subscription clause state? The subscription clause states the names of subscribers to memorandum. It states the number of shares which they have subscribed to, their signatures, and it also states the name of the witness in whose presence they have signed the document. So, all of this is stated where? In the subscription clause. And in addition to all of these clauses, there is one nomination clause. Now, this nomination clause is only there in case of a one person company. Nomination clause will be there only and only in case of one person company. And what will it state? It will state the name of the person who is appointed as a nominee. It will state the name of the nominee. Nominee is the person who will become the member upon death of the member of a one person company. So nomination clause will be there only in case of a one person company, not in case of any other company at all. So these are all the clauses of memorandum of association which we have understood in under section 4. Now after section 4 we started with section 5. Section 5 was about articles of association of the company. What are articles of association of the company? They are nothing but rules and regulations, bylaws for internal management of the company. So they are what? They are rules, regulations, bylaws for internal management of the company. It is all stated in the articles of association of the company. Then we also understood that articles of association of the company can include a provision called as an entrenchment provision. An entrenchment provision is difficult or rather impossible to modify. Now this entrenchment provision can be included either at the time of incorporation, that is formation of the company, or later on. If the entrenchment provision is being included later on, then in that situation, if the company is a private company, then consent of all the members will be required to include the entrenchment provision in the articles of association. And if it is a public company, then the consent of members will be required by way of a special resolution. And that's how the entrenchment provision can be included in the articles of association of a company. And as and when we include the entrenchment provision, we will also have to inform the registrar about the same. Inform the registrar about inclusion of the entrenchment provision in the articles of association of the company. Now post this, we also saw two doctrines. Doctrine of constructive notice, which says that a person who is entering into any transaction with the company, he is deemed to have knowledge of the contents of memorandum of association and articles of association of the company. So there is a presumption that any person who is entering into any transaction with the company has read and has gone through its public documents and has knowledge about how his money is going to be utilized. The person is aware of that fact. However, there are certain situations wherein a person will not know about how the internal affairs of the company are being managed, and that's where the doctrine of indoor management comes to his rescue. So this doctrine of indoor management is the exception to the doctrine of constructive notice. So it basically protects the person from not knowing about the internal affairs of the company, not knowing about how the internal affairs of the company are being managed. That is what is stated in the doctrine of indoor management. However, there are three exceptions to this doctrine as well. One is where a person has knowledge about irregularity, where a person already knows about irregularity but still enters into the transaction. Second situation, where the person is being negligent. And third situation is in case of forgery. So these are the three exceptions to the doctrine of indoor management. So we understood the doctrine of constructive notice, then we also understood the doctrine of indoor management, and also what are the exceptions to the doctrine of indoor management. So we have done all of that. This was with respect to section 5, articles of association. After section 5, when we started with section 6. Section 6 was a very small section, and it basically talks of the act will override whatever has been stated in the memorandum of association, articles of association, any contract or agreement which is entered into by the company. So what does section 6 say? Section 6 says act will prevail over the memorandum of association, articles of association, any agreement made by the company, so in all the situation, what will prevail? The act. The act means the Companies Act will prevail over all of these documents which are made. So if there's anything which is conflicting with the memorandum, between the memorandum and the act, what will prevail? The act will prevail, not the memorandum of association. So that is what section 6 says. It says the act overrides, the memorandum, articles or any agreement which are made by the company. That is section 6. Moving ahead, the next section which we understood was section 7, and section 7 was about incorporation of a company. Now for the purpose of incorporation of company, first requirement we saw under section 3, that is the minimum number of members. What are the different things which shall be filed with the registrar for the purpose of incorporation of a company? So the first documents which shall be filed with the registrar were the signed MOA and AOA, signed memorandum and articles of association of the company. So the first documents which shall be submitted to the ROC is signed MOA and AOA. Which form is filed? Spice Plus or INC 32 is the form which is filed for the purpose of incorporation of a company. When we talk about signing of the memorandum of association and articles of association, if an individual is becoming the subscriber to the memorandum, then the individual shall sign there in the subscription clause in the presence of at least one witness. If the individual is an illiterate person, then in that situation he should affix his thumb impression, and there should be signature and his details and signature shall be done by some other person, written by some other person in presence of a witness. If a body corporate or if a company is becoming a member or is a subscriber to the memorandum, then they should appoint their authorized persons, and the authorized persons should sign on behalf of the body corporate. So these are the people who are going to sign the documents. Now talking about what other documents are required or what other attachments should be filed along with INC 32. So the other attachments include 2 declarations. It includes 2 declarations. These are 2 declarations, one which is given by the professional plus director, or manager or secretary. The second declaration is given by the subscribers to the memorandum plus the first directors. Now in these declarations, what shall we be stating? So in the declaration which is given by the professional and the director, they shall state that they have complied with the provisions of the Companies Act for the purpose of formation and incorporation of company. They have complied with rules and regulations for the purpose of formation and incorporation of the company. And in the second declaration, which is given by the subscribers to the memorandum and all of the first directors, what are they going to state in their declaration? One, they will have to state that they have not been convicted of any offense. Not convicted of any offense which leads to formation, incorporation, promotion of a company. 2, they have not been found guilty of any fraud they have not been found guilty of any fraud in matters related to formation and incorporation of company during the last 5 years. And the last point which they state here is all the information is true and correct. All the information is true and correct to the best of their knowledge. So these are the two declarations which shall be filed. Apart from these two declarations, what else has to be stated? We'll also have to state the address for correspondence till the time the registered office is established. So we'll state address for correspondence. We'll have to give details of all the first directors of the company. Details of first directors. What details of first directors do we give here? In details of first directors, we give details about their name, residential address, identity proof, and all of the other details required by their interest. All of that will be declared. All of that will be in a form which is attached to the Spice Plus form. Apart from it, we'll give details of any other particulars required. Any other matters required, will have to attach all of this to the incorporation form and file all of this with the registrar of companies. Now, after we file the documents with the registrar of company, what will the registrar do? We'll file all of these documents with whom? We'll file all of these documents with ROC. After he receives the document, he'll inspect and he can order for two things. One is he is satisfied. Second, he is not satisfied. If the registrar is satisfied with the documents which have been filed with him, then what will the registrar do? He will register the company, issue certificate of incorporation. In the certificate of incorporation, he'll allot a SIN to the company. SIN is a 21-digit alphanumeric number which is given to the company. It is the corporate identification number. So the registrar will allot the certificate of incorporation. It will contain the SIN and also the date. The date on the certificate of incorporation is the date of formation of the company. That is the date from which the company comes into existence. However, if the registrar is not satisfied with the information which is provided to him, then he can call for additional information. If he is not satisfied with the information, then he can call for additional information if required. This is what the registrar will do. Now, after all of this is done, again there is one more situation which may arise. That is, what if any false or incorrect information was given for the purpose of incorporation of the company? What will happen in that situation? If any false or incorrect information was given by a person for the purpose of incorporation of the company, and let's say first case, the company has been incorporated. If the company has already been incorporated, then in that situation the case will go to the tribunal, and tribunal will pass such orders as it may think fit. They may make the liability of members unlimited. They may strike off the name of the company from the register of members, wind up the company, or pass any orders as the tribunal may think fit. And before passing orders, the tribunal will have to give the company an opportunity of being heard. And also there will be punishment under section 447. This is the situation where the company has already been incorporated. However, say company has not yet been incorporated. If the company is not incorporated, then what? Then the incorporation process will stand by, it will not go ahead, and the persons involved will be punished under section 447. persons involved will be punished under section 447. This is what will happen if any false or incorrect information is furnished for the purpose of incorporation of a company. So if any false or incorrect information is furnished, then the persons who are giving this false or incorrect information, they will be punished under section 447. 447 gives us the punishment for fraud. So these people, they will be punished under section 447 of the act. And if the company has already been incorporated, then in that situation the issue will go to the tribunal, and tribunal will pass such orders as it may think fit. Whatever the tribunal thinks fits the situation, the tribunal will pass such orders. That is what section 7 talks about, the incorporation of the company. Now that we have understood section 7, let's move on to section 8. What does section 8 talk about? Section 8 talks about a section 8 company. So what is a section 8 company? Section 8 company, as you all know, is a company which has been started with some charitable objective. So what is the objective? Charitable objective. Could be promotion of education, eradication of hunger, and promoting some science, art, culture. All of these are the objectives of a section 8 company. Now when we talk about a section 8 company, these companies are also called as licensed companies. And these companies require what? They require a permission or license from the central government. They'll require to obtain a license from the central government, and only after that the company can start functioning. So what is the process of incorporation of a section 8 company? If a person wants to incorporate a company which is a section 8 company, he'll first have to obtain central license from central government. And when the central government gives the license, it obviously gives license with certain terms and conditions. Now the section 8 company should define its objectives, what are the purposes for which the company is being incorporated, and what are the different objectives which the company is going to carry out. So that is one. Then we've also understood that a section 8 company cannot utilize profits for any other purpose. Whatever purpose is the main purpose of the business, main purpose of the organization, only for that purpose the profits can be utilized. It cannot utilize profits for any other purpose. And we've also understood that a section 8 company cannot distribute dividend to its members. Cannot distribute dividend to its members. This company cannot distribute any dividend to its members, and if it does so, then it is in violation of section 8. And if there is any profit which is arising to the company, that profit also has to be utilized only for the objectives with which the company has been incorporated. So these are a few points which you should remember about a section 8 company. And in case of a section 8 company, we have also understood that the notice of meeting shall be sent only 14 days in advance. For normal companies it is 21 days, but for a section 8 company it is 14 days. Now when a person is applying for the purpose of incorporation of a section 8 company, what are the documents which he is going to file with the registrar? Like all the companies, he is also going to file the memorandum of association and article of association. He will file MOA and AOA. But apart from MOA and AOA, they'll also have to file some other documents. They'll have to state what is the income and expenditure of the organization. So they'll have to file MOA and AOA with the ROC. They'll also have to file the approval which they have received from the central government, the license which they've received from the central government with the registrar of company. And this section 8 company can also be converted into a public company or a private company whenever they want to. However, when we incorporate a section 8 company, the name of section 8 company need not have any suffix limited or private limited after its name. It is not required in case of a Section 8 company. And then we also understood that in case of a contravention, in case there is some contravention, then what is the power which the central government has? CG can revoke license. Can revoke license. And when the central government is revoking the license, what are the things which the central government can do when it is revoking the license? One is they can order winding up of the company. They can order winding up of the company. 2, they can ask the company to amalgamate with some other company which has similar objectives. And 3, they can change the name of the company, change the name and convert the company into either a public or a private, convert it into private or public company. This is what can be done. Now, when we talk about winding up of the company, when the central government is revoking the license and is asking the company to wind itself up, the surplus assets, if there are any surplus assets, after paying off all the liabilities, if there are surplus assets left, then what will be done with these surplus assets? 2 things can be done. 1, it can either be transferred to another Section 8 company, transfer to Section 8 company, or it can be transferred to the insolvency and bankruptcy fund. So this is what can be ordered by the central government. However, when the central government is passing any of these orders, in that situation the central government will first have to give the company an opportunity of being heard. So an opportunity of being heard has to be given to the company before the central government passes any order. Now that we have understood what is a Section 8 company, let's also quickly recap of what a one-person company is. So what is a one-person company? It is a company with only one person as its member. So there's only one member in this one person company. And we have understood that when a person is incorporating a one person company, he'll have to do what? He'll have to give a name of a person who will act as his nominee. So in case of one person company, the member shall nominate a person as his nominee. Shall nominate his nominee. Now, before nominating any person as nominee, we have understood that what is required? A written consent is required. Written consent of nominees required. Now, both situations are possible. The nominee can be changed at any point of time. Nominee can be changed, or nominee can withdraw his nomination. Both the things are possible, both the situations are possible. The member can change his nominee, or it could be a situation wherein the nominee himself withdraws his nomination. Both the things are possible. Now, when we talk about member changing the nominee, when a person is changing his nominee, he'll have to give a written notice to the nominee. And when the nominee is withdrawing his nomination, in that situation also he'll have to send this information in writing. And when a new nominee is appointed, new nominee's written consent is also required. New nominee will also have to give his written consent before he is appointed as the nominee. So these are a few things which have to be kept in mind when we are talking about a one-person company. Now coming to who is eligible to become a member and a nominee. So in order to be eligible, a person has to be a natural person, Indian citizen, whether resident or not. Whether resident in India or not. So it is not mandatory that the person has to be a resident in India. He may or may not be a resident in India. Residential status is not mandatory. Again, who is a resident of India? A person who has stayed in India for not less than 120 days in the immediately preceding financial year. That person is said to be a resident of India. And this one person company also can change into a public company or private company at any point of time. A one person company cannot be formed as a Section 8 company or cannot be converted into a Section 8 company at any point of time. So this is one asterisk mark. A one person company cannot be formed as a Section 8 company and can neither be converted into a Section 8 company. So these are a few points which you have to keep in mind about a one person company. So now that we have completed Section 8, let's now move ahead to Section 9. So Section 9 is a very basic section wherein we've understood what will be the effect of registration of a company. And Section 9 tells us that as soon as the company is incorporated, it will get the powers, it will be treated as an artificial person, artificial legal person in the eyes of law. And not only being treated as an artificial legal person, but it will also get the power to enter into agreements, enter into contracts. Not only that, will have power to acquire, sell and hold assets, and will also be able to sue others and be sued upon in its own name. Power to sue others and be sued upon in its own name. So these are the powers which an artificial legal person has. A company upon registration will get all of these powers. And similarly, we saw the next section, Section 10. Section 10 talks about what will be the relationship, what will be the effect of MOA and AOA. So MOA and AOA, they basically establish the relation between company and members, members and company. So the MOA and AOA, they basically establish the relationship between the company and its members, members to the other members of the company, and also the members to the company, also company to the outside world. So this is what the effect of MOA and AOA is. And then there's another section which was Section 10A, which talks about commencement of business of company. So therein we have understood that within 180 days of incorporation, 180 days of incorporation of a company, what has to be done? In 180 days of incorporation of a company, the subscribers to the memorandum will have to send a declaration. A declaration has to be sent to the ROC stating what? That the subscribers have paid up all the amount on the shares which they had taken. Subscribers have paid all the amount for the value of shares they had taken. And the second point in the declaration is that registered office is established. So this declaration has to be sent to the registrar in how many days? In 180 days from the date of incorporation of the company. What if this declaration is not sent to the registrar? Then in that situation, what will happen? If no declaration is sent, registrar will assume that the company has not started doing its business operation and will take steps to remove the name of the company from the register of members. However, this will be done by the registrar only after giving the company an opportunity of being heard. So this was section 10 and section 10A. Moving ahead to next section which we understood, it was section 12. Section 12, under section 12 we've understood that this talks about the registered office of the company, wherein we have understood that within 30 days of incorporation, a notice has to be sent to the registrar, a form has to be filed with the registrar stating that the registered office has been established and also a verification of registered office has happened. So within 30 days of incorporation, this form has to be filed with the registrar stating that the registered office of the company has been established and also a verification of the registered office of the company has happened. So this has to be communicated to the ROC within 30 days. Then under section 12 we have understood that if then under section 12 we have also understood about how the labeling has to be done. At every registered office of the company, the name of the company should be written in a conspicuous and a legible manner, and the name, SIN, address, email address, phone number, all the other details shall be present, and all the letterheads, all the important letterheads and documents of the company. And in case there is a change in the name of the company, then the previous name, that is the old name, should also be written along with the new name for 2 years. To just give you an example, earlier the name of, there is a company Eternal Limited. Now this Eternal Limited was earlier known as your very own Zomato. So now whenever you receive any communication from this company, or if you look at the letterhead of this company, or if you visit the registered office of this company, you will find the new name Eternal Limited written, and below it in brackets or after it in brackets they'll also write formerly known as Zomato. Now, in a situation when there is a change in the name of the company, what are we going to do? We'll also write the old name, we'll continue writing the old name for 2 years. Why is it done? So that people are also acquainted with the new name, and it takes 2 years time. So that is the reason why we continue writing the old name besides the new name besides the name of the company. So this is what is done at the registered office and labeling of name. And then we also understood about change in the registered office of the company. When we talk about change in the registered office of the company, here we discussed 4 situations. One was within city, second was within state but city change, third was within state but there was a change in the jurisdiction of ROC, ROC was changing, and fourth was outside state, or let's say other state, moving the registered office to another state. So what are the permissions and what are the things which have to be complied with whenever there is a change in the registered office? So if it is happening within city, then a normal board resolution would be sufficient for the purpose of changing the registered office of the company. We will just pass a normal board resolution and send a notice to the ROC within 30 days of the resolution. So that is sufficient if it is within the local limits within the city. However, if it is within the state but there is a change in the city, then will require a special resolution, and only special resolution, and after that we will send the notice to the ROC in 30 days. However, if it is within the same state but the jurisdiction of ROC is changing, say you are moving from ROC Mumbai to ROC Pune, then what? Then in that situation we will first have to obtain approval of regional director. we will first have to obtain approval of regional director, and after the regional director gives his approval, so we'll basically need a special resolution, then we'll also need approval of director, regional director, and then we'll send the notice to ROC after receiving the approval of regional director. So this is the process where there is change in the jurisdiction of ROC. So if the jurisdiction of ROC is changing, we'll need approval of the regional director. What if we are changing the state itself? If there's a change in the state, then in that situation, we'll pass a special resolution, obtain approval from the central government via regional director, inform the regional director about it, and also inform the ROC about the approval received and about changing the state where the registered office is situated. Now, when the registered office is moving from one state to another, in that situation, we will have to inform the ROCs of both states. ROC of both states shall be informed about it, and in this situation a fresh certificate of incorporation will be issued by the ROC of the state where the registered office is being shifted. So these are a few things which you have to keep in mind when we are talking about change or shift in the registered office of a company. Moving ahead, that was section 12. Moving ahead, section 13, which was again a very important section wherein we have discussed about alteration of memorandum. Alteration of memorandum. Now, since we have understood that there are different clauses in the memorandum, in this section we also understood that different clauses will be altered in different way. In order to make any change in the memorandum, the first and foremost thing which is required is a special resolution. If we want to make any changes to the memorandum of association, we'll first have to pass a special resolution. Special resolution is required. Now, talking about how are we going to change the name of the company, how are we going to alter the name clause. So when we talk about change in the name of the company, if you want to change the name of your company, the first thing required is approval from central government. Approval of central government is required if you want to change the name of your company. So only after obtaining the approval of central government, you can change the name of your company and file the approval received from the central government as well as the documents required for purpose of changing the name with the registrar. But first thing required is a special resolution along with central government approval. So approval of CG plus a special resolution is required for the purpose of name change. However, we have understood that if the name change is because of conversion of company from public to private or private to public, if the name change is because of conversion of company, then in that situation, no approval is required. Why is no approval required in this case? Very simple. For the purpose of conversion, we have already taken the approval of central government, and since we are converting, it is by default that the name of the company will change. Because of that, word private will either be added or removed. So that is the reason why no specific approval of central government will be required in that situation. And we have also understood that if a company will not be allowed to change its name if it has made a default in filing its financial statements, annual returns or any other documents. So there should be no default in filing documents with ROC, filing financial statements, annual returns with the registrar of company. So there should be no default like that in place. So this was with respect to changing the name of the company, and when we change the name of the company, at that time also we can reserve the name of the company for certain time span. Then moving ahead to the second clause, which was the situation clause. Under situation clause, we have already understood that what are the approvals which are required for the purpose of changing the registered office of the company. So that is what we have already discussed in here, that how will the change in registered office be affected. So this is as discussed under section 12. So for different changes, we'll pass different resolutions and different people's approval will be required if we are changing the registered office of the company. Moving ahead, the next clause and the most important clause, object clause. However, there's one point which we did not discuss here, okay. So as discussed under section 12, that is okay, but when we are changing the registered office from one state to another or from one place to another place, what are a few points which have to be kept in mind? We'll have to make sure that we have sufficient provision made for the purpose of discharge of any debts or liabilities which are already existing. So the company, when it is changing its registered office, it will have to make sure that they have obtained sufficient provision has been made. So when we make an application to the central government will make sure that these three things are in place. 1. Sufficient provision should be made for the discharge of all the existing debts and liabilities. 2. Consent of creditors, debenture holders, whether it has been obtained or not. And 3. Adequate security shall be present for the purpose of discharging all the debts and liabilities of the company. So these three things, who will make sure that these three things are in place? It is the central government. On receipt of an application, they'll make sure that all of these things are in place, and only then the central government will give its approval for the company to change its registered office from one state to another state. And such a notice or such information shall be filed with registrar of both the states, and then the registrar of new state will, upon satisfaction, issue a fresh certificate of incorporation to the company. So that was with respect to situation clause. Moving ahead to the next clause, which is our object clause. So when we talk about the object clause, in order to alter the object clause, what is required? Special resolution by postal ballot. We need a special resolution by postal ballot. And when we send the notice of this resolution to be passed, when the notice is being sent, there are a few things which shall be stated in the notice. What should be stated in the notice? The total amount raised, amount utilized, unutilized amount, not only that, we'll also have to state what are the new objects of the company, and also their financial impact. All of this shall be stated in the notice which is being sent to the members for the purpose of passing of the special resolution via postal ballot. And in this situation, we've also understood that the dissenting shareholders will be given an exit opportunity. Dissenting members or shareholders, they'll get what? They'll get an exit opportunity. Dissenting shareholders, that is shareholders who are not in the favor of change, they'll get an opportunity to exit. So this is how the company is going to change its object clause. Always remember, if there is anything which is done beyond the powers of the company, that is under the doctrine of ultra vires, it cannot be ratified even with unanimous approval from all the shareholders. Even if all the shareholders agree, even in that situation, that thing cannot be ratified. So this is what the object clause, this is how the object clause of the memorandum of association can be altered. See, I am not writing everything in detail here because we are doing a summarized version of the chapter, and when we do a summarized version, we make sure that all the important points are covered. So we are covering up all the important points here. So this is how the object clause will be changed. Now talking about the liability clause, similarly, in order to alter the liability clause, when there is a change in the liability and say if it leads to an increase in the liability of its members, if there is any increase in liability of the members, then in that situation we will have to obtain consent of all the members. When there is any increase in the liability of members, then consent of all the members will be required. And with respect to capital clause, for now I have only told you that a special resolution will be required. However, the remaining part we will discuss in chapter 4, share capital and debentures. So with respect to the capital clause, we will discuss in chapter 4, share capital and debentures. So this is how we change, or this is what, these are the requirements for the purpose of alteration of memorandum or making changes in the memorandum of association of a company. Then moving ahead to the next section, section 14. Section 14 talks about alteration of articles of association. Talks about alteration of AOA. And it tells in order to alter the articles of association of the company, one thing which is required is the special resolution. We can pass a special resolution, and on the basis of special resolution we can make changes in the articles of association of the company. So for the purpose of conversion of articles, a special resolution is required. However, if it relates to conversion of say a public company to a private company, if it is public company to a private company, then in that situation what is required? In that situation, additionally an approval of central government is required. Approval of central government is required, and as and when we receive the approval, we will file it with the registrar of companies. So why public company to private company conversion has been addressed here? Reason being very simple. The restrictions which are there in case of a private company are there in its articles of association. So in order to convert a private company into a public company or a public company into a private company, the main place where the change has to be made is in the articles of association of the company. That is why this particular point has been given to us under this head. Moving ahead, section 15, very simple section. It says that whenever we are making any alterations to the memorandum of association or the articles of association of the company, it should appear in all the copies of the memorandum of association and the articles of association. So the changes which are made, whenever we are making any changes in the MOA or AOA, it should appear in every copy of MOA and AOA, whether physical or electronic form. Whether physical or in electronic form. We will have to make changes everywhere. If we are making changes at one place, it should appear at every place. Then moving ahead to another section, section 16. What does section 16 talk about? Section 16 talks about the rectification of the name of company. When will rectification happen? When there is a mistake in the name of company. So here, how can the rectification in the name of the company be done? By central government making an order. Now before the central government makes an order, an application will be filed with the central government. On any application received by central government, either by any person or suo moto, the central government comes to know that a company has been formed with a very identical name, or an application which is filed by a person holding registered trademark. Person holding registered trademark. Now here the person holding registered trademark can file an application only within 3 years from the date of incorporation of a company, not exceeding that. So who is the application being made with? The application is being made to the central government. Upon receiving such an application, the central government, when it finds out that a company has been incorporated which is with a very similar name or the name is too identical with name of any other company or registered trademark which is already in existence, then in that situation what will the central government do? They will pass an order. They'll pass an order. In the order they will direct the company to change its name. Direct the company to change its name. What is the time period which it is giving? It gives the company 3 months to change its name and by way of an ordinary resolution. And after the company changes its name, what will the company do? Company will inform the ROC about the change, and then ROC will update the certificate of incorporation and also the memorandum of association and will issue a fresh certificate of incorporation. However, what will happen in a situation where the company fails to follow the order or direction which was given by the central government? In a case where the company fails to follow the directions of the central government, in that case the central government will itself allot the name to the company. So in case of failure, the central government will allot a new name. Central government will allot a new name, inform the ROC, ROC will directly issue the fresh certificate of incorporation. However, in this situation also the company can later on change its name as per section 13, that is altering the name clause of the memorandum of association. So this was what we understood under section 16, wherein we have understood that how will the central government pass an order in order to rectify, in order to change the name of the company, wherein by mistake the name of the company is very identical with name of any other company which is already in existence. Then moving ahead to section 17. Section 17 says, when any member of the company, any person is making an application to obtain a copy of, say, memorandum of association or articles of association of the company or any resolutions of the company as specified under section 117, then in that situation, within 7 days, the company shall provide the copies of documents which have been demanded by the members. And also when the member is making an application, application shall be accompanied with fees. So application shall be accompanied with fees. The application which is made by the member should be accompanied with some fees, and as soon as the company receives an application like this, within 7 days the company has to make sure that it is providing the documents to the person who has made an application. So this was section 17, a very simple section, and in case of default there is penalty. Moving on to section 18. Now, section 18 talks about conversion of companies which are already registered. Conversion of companies. What does section 18 say? Section 18 says that if a company wants to convert itself, then it will first have to make changes in its memorandum of association and articles of association. So, it will first have to alter its MOA and AOA. In order to convert itself into any other type of company, the company will first have to change its MOA and AOA. How do they change its MOA and AOA? For the purpose of alteration of MOA, they will have to follow section 13, and for AOA section 14 of the Act. Once they alter MOA and AOA, what are they going to do? They are going to inform the ROC about it. The ROC, upon receiving the application, upon inspecting the application, will thoroughly check all the things, and if the ROC is satisfied, what will he do? The ROC, upon satisfaction, he will close the former registration, that is the previous or older registration, and he will issue a fresh certificate, issue a fresh certificate of incorporation. So this is what the ROC will do, and this is the section 18 which talks about how can a company be converted. Moving ahead, the next section which we saw was section 19. Section 19 tells that a subsidiary company cannot hold shares in its holding company. So what does section 19 say? Section 19 says that no subsidiary shall hold or purchase shares of its holding. So no subsidiary company shall hold, purchase or be allotted with any shares of its holding company. It is not allowed. However, there are three exceptional situations. Three exceptional situations where a subsidiary can hold shares in its holding company. What are they? The first case is where the subsidiary is holding shares in the capacity of a legal representative. It is holding the shares in the capacity of a legal representative of whom, of member, of deceased member of holding company, of deceased member of a holding company. So if the subsidiary, it is holding shares in the capacity of a legal representative of a deceased person, deceased member of a holding company, then that is okay. Then second exception to this is where the subsidiary is holding shares as a trustee. If the subsidiary is holding shares as a trustee, then okay, fine, no problem. And the third exception to this is where the subsidiary was already holding shares even before it became a subsidiary company. So if the shares were already held even before the holding subsidiary relationship was established. Holding subsidiary relationship was established. So then in that situation as well, the subsidiary can continue to hold shares in its holding company. But talking about purchasing new shares in the holding company, being allotted with some shares of the holding company, that cannot be done. And the subsidiary company will also not have any voting power when it is holding shares as a legal representative or a trustee. So that was your section 19, wherein we have understood as to subsidiary company should not be holding shares in its holding company. Moving ahead to section 20. Under section 20, we have discussed about service of documents. What are the modes which have been prescribed? The modes which have been prescribed for the purpose of service of documents is registered post, speed post, courier service, registered post, speed post, courier service, or any electronic means, electronic mode, or any other manner as may be specified. So these are the ways in which any communication can be sent to the registered office of the company. See, in order to communicate with the company, the communication has to be sent to the registered office of the company. We cannot send all of the important notices or all of the important documents at the residential address of the directors. No, that will not mean serving the document to the company. The document will be served to the company only when we address it to the company and send it at its registered office. And in the similar way, we are also going to communicate with the members of the company as well as the registrar of companies. In the similar manner, we will also send documents to the members of the company, and also when the company has to send any information to the registrar, it can use any of the following way. And in the similar manner, the members of the company and also the registrar are going to communicate with the company. So this was section 20, which talks about service of documents, and we have also seen a few questions based on this. And here there's one more specific point which says that if member has prescribed a specific mode, if member has specified a mode, that service of documents to me should happen in that mode only, then the communication, then the service of documents should be happen in that particular mode only. If it is being done in any other manner, then it will not be treated as a valid service of document. So this is one point which has to be kept in mind. And then we've also understood that if the documents are being sent by post, then we say that the document has been delivered in 48 hours. Time of delivery which we assume here is 48 hours. And email, there's instant communication. So this is what section 20 talks about. Moving ahead to section 21. Section 21 talks about authentication of the documents of the company. So when we talk about authentication, there are two situations: company having common seal, company not having any common seal. So if the company has a common seal, then the documents of the company shall be authenticated by the common seal which is present. However, if the company does not have a common seal, then what? Then again two situations may arise. Company has a company secretary, company does not have a company secretary. So if a company secretary is appointed, then in that situations the document shall be authenticated by one director and one company secretary. One director and one company secretary. And when no company secretary is appointed, then in that situation the document shall be authenticated by two directors of the company. So section 21, it talks about authentication of documents. Moving ahead to the last section of this chapter, and the last section was section 22. So when we talk about section 21, it talks about the authentication of documents. So documents of the company, all the agreements, contracts, who is authorized to sign all of these documents. So any key managerial person of the company, any KMP of the company, or any officer or employee authorized in this behalf. Any KMP or any officer or employee of the company who is authorized in that behalf, they are the people who are eligible to sign on the documents of the company. Let's now move ahead to the last section, which is section 22. What does this section say? This section talks about when will the bills of exchange, promissory note, hundis made by the company, made, accepted, drawn, delivered, endorsed by the company be valid. So they'll be valid only when they are made, accepted, drawn, delivered, endorsed by any person who is authorized to do that on behalf of the company. If it is done by any authorized person, then that will be valid. Done by an authorized person, it will be valid. Now, who is authorized to do it? So who is an authorized person? In case of a company which has a common seal, in such a situation, a person may be authorized in writing under the common seal, under the seal of the company. That this is the person who is the attorney who has the power to authorize all the documents on behalf of the company. So this person will do what? He'll affix the common seal of the company to the documents. But what if the company does not have any common seal? If there is no common seal, then what? Again, two situations will come up here. One, the company has appointed a company secretary. Two, no company secretary appointed. Then what? If a company secretary has been appointed, then the authentication shall be done by one director and one company secretary. This is in a situation where the company secretary has been appointed. However, if no company secretary has been appointed, then in that situation the authentication shall be done by two directors of the company. In case a company secretary is appointed, then one director, one company secretary. In case no company secretary has been appointed, then two directors of the company shall be authorized, shall be liable. Then in that situation, two directors of the company will authorize the documents of the company. So this was section 22. So with this, we have completely summarized the entire chapter in a very detailed manner. So we've done a very detailed summary of the entire chapter. And this summary will help you in your last minute preparation. So this will help you in quickly brushing up all your concepts. See, summary videos are meant to discuss things in short and also for you to recollect things, right? So with this, we have now completed your chapter 2, which was on incorporation of a company, wherein we have covered section 3 to section 22.